Morena tātou. We'll just give everyone a few minutes to get started. Good morning if you're just joining us. We'll just give everyone a few minutes to join the Zoom link. This morning, we're going to be talking about disclosure and advertising, but we'll just give everyone a moment to log on. Good morning, everyone. Right, so we've waited a minute for everyone to get started. So we'll just wait another moment or two more and then we'll begin our session on disclosure and advertising. Tēnā koutou katoa, nā mihi nui kia koutou katoa, no mai haere mai. It's my pleasure to welcome you to the first of our 4 in-depth seminars on the changes to credit laws. So first of all, I'm going to start straight out by apologising for the fact that I am in Auckland in lockdown and working from home. And my neighbour 2 doors up is currently weed eating their lawn. I really apologise for the background noise. I will try and mute on and off so that I'm not a distraction. So, welcome again to our in-depth seminar on disclosure and advertising as it relates to the changes to the credit law. Many of you will have attended our overview seminar a couple of weeks ago. And if you missed it and you want to see a high-level summary of the Commission discussing the 5 main areas that are changing, and these are responsible lending, due diligence, directors' duties, fees and advertising and certification, as well as hearing from Commission leaders talking about the education and enforcement approach the Commission's taken, then you can find a recording of that session on our website. And there's a link just popped up in the chat. We also made a series of informative handouts. Now, these are quite detailed and they cover off the main changes that are underway. If you've not received these, they're available on our website. And again, the link's going to pop up in the chat function. Now, I'd like to thank you all for filling in the surveys at the end of the last seminar. Your questions were really thoughtful. They were relevant and they've helped us make sure that these in-depth sessions deliver information that you want to hear about. We've used your queries to structure the discussion today, and so we hope that's useful for you. There'll also be a chance today to ask questions live so that we can make sure that we're giving you the information that you need. So, as you know, today's session focuses on disclosure and the key aspects about advertising. And our expert, the Chief Legal for Credit for the Commerce Commission, Crystal Uden, she'll be addressing some of your questions and, as I said, available for an informal Q&A chat session at the end. So first, I'll open with karakia. Whakataka te hau ki te uru, whakataka te hau ki te taonga. Kia mā kena ki huta, kia mā taratara ki tai. E hia ki ana te atakura, he tio, he huka, he hauhunga, tihei mauri ora. Now, before inviting Crystal to speak to you all, I'll quickly go over some housekeeping. If you have a technical issue and you need a hand, you can raise your virtual hand. It's under the reactions on the bottom of your screen, and we'll see if we can assist in the chat function. You can also use the chat function to ask any questions that arise for you during our discussion today. Now, as last time, Penny Fitzpatrick is handling our Zoom, and I'd like to introduce you all to her now. Welcome, Penny, and thanks for helping us out.
Kia ora, Sonia, and kia ora koutou. As Sonia said, I'll be handling the chat function today and putting through any of your questions to Crystal. You can pop these in the chat function or note them down and pop them in the survey or email them to us after the webinar. Kia ora.
Thanks, Penny. Right, and now today I'd like to welcome Crystal Uden. As I said, she's our head of legal for credit, and she's given lots of thought to the changes around disclosure. Welcome, Crystal.
Thanks, Sonia. No mai, haere mai, and welcome to this in-depth discussion on the upcoming disclosure and advertising changes. I'm Crystal Uden, and as Sonia mentioned, I'm the Commission's Chief Legal Counsel of Credit. This is my 6th year at the Commission. Some of you may recognise me from having come in and spoken to you before. I've been working exclusively in credit in my time at the Commission, so just like most of you, I live and breathe credit. If you're logging in again today, having already seen me speak a couple of weeks ago on disclosure, and especially on a Tuesday after a long weekend, my condolences. I really do appreciate you logging in again to hear about what can sometimes be considered an unexciting topic. So your presence today to hear more about disclosure and a little bit of advertising either means that you are so excited to hear me speak again that I could probably talk about anything, or I did my job right and I explained to you the importance of correct disclosure. And for lenders, as we know, the consequences can be quite serious if they get it wrong. So I'm glad you're here to find out more about what they can and can't do. But wait, like I mentioned, there is more to this session than just disclosure. I'll be covering some of the questions that came in about advertising. Some changes will fall under the disclosure of information when advertising, and so I'll also be covering those a bit later. So for everybody joining us today, new and old, please buckle up and get ready for an in-depth ride into the wonderful world of disclosure and advertising. To kick things off, as the purpose of today is to go through the changes and answer some of your questions from last time, together with some live Q&A at the end, I thought we should kickstart this by starting with a question from you. So Sonia, could you please do the honours?
I sure can. So we had lots of questions about mobile traders, and a couple of the questions were about whether the disclosure obligations, both old and new, apply to mobile traders. What should mobile traders be doing?
Well, that's a good one to start with, because I can tell you that everything I talk about today applies equally to lenders and mobile traders. So I think to cover off first, every time I talk about the Act today, obviously I'm referring to the Credit Contracts and Consumer Finance Act. And the Credit Contracts and Consumer Finance Act, or CCCFA as I often call it, has a specific definition for mobile traders. It is quite a legal definition, and I'll mention it, but what you just need to remember is what you currently think of as a mobile trader is still a mobile trader. So the CCCFA defines mobile trader as someone who in person and not at fixed premises, so someone in person and not in a building, they offer or agree to supply consumer goods to an individual, either under a credit sale directly with themselves, or where the goods are partly or fully financed by an associated company under a consumer credit contract. So again, it's a long definition, but if you think of a mobile trader as someone in a truck who goes door to door selling consumer goods, then you're on the right track. So the Act says that mobile traders who meet that definition and enter into credit sales for consumer goods, then they're deemed to be creditors under the Act. And what does that mean? Well, that means they're covered by the Act. Everything that the Act talks about when they say a creditor, they're meaning a lender and now also a mobile trader. So to answer the question, as creditors under the Act, then they're required to comply with all of the disclosure requirements. There are many. There's the initial disclosure we know about from Schedule 1, continuing disclosure, variation disclosure, request disclosure, guarantee. The list goes on. They all apply to mobile traders. So definitely be looking out for that when your customer comes in, your client comes in and they've got a contract with a mobile trader. There's nothing special or extra that mobile traders need to do. Lenders and mobile traders have the same obligations. And again, it's quite a big change. It came in a year and a bit ago, so they should have their houses in order. But yeah, happily, the mobile traders are now covered by all of the Act.
That's fantastic. It's really good to get that clarity. So the lenders and mobile traders have the same disclosure options. That's great, Crystal. Thank you. Hey, now before you start taking us through what's changing, I think it would be helpful to talk to us about the disclosure basics first, a little bit like what you did at the last seminar.
Yeah, no problem. And I won't quiz you on them, so don't worry. There are 4 core types of disclosure already in play. These ones you guys will all know about, but just for a refresher, we have initial disclosure under Section 17 of the CCCFA. That's the stuff that must be provided at the beginning before your client enters into the loan. It's all the stuff in Schedule 1 of the Act, which is at the end of the CCCFA. If you look that up on legislation.govt.nz, and Penny will pop that in the chat box for you. That's all the things that you can find in Schedule 1. And if lenders don't disclose it, then the default position, as we know, is that they can't collect the interest and fees until they do provide that information. Sometimes that will mean a refund.
Hey, so one of the questions we had come through, Crystal, I think it could be relevant now. So we had a question, and again, I'm going to apologise for the weed eater in my background.
That's not too bad.
I'm glad. I hope it's not a distraction. So, Crystal, we had a question about the cooling off period. Does the lender have to disclose this with the initial disclosure?
Yeah, yes, they do. Now, the trick here is it's not called a cooling off period. It comes under the cancellation rights. So that's in Schedule 1. You'll see there's a specific provision about the lender disclosing that the borrower has a right to cancel within a certain number of working days. They must tell the borrower about that right to cancel. And if they don't, then proper disclosure has not been given. There are different timeframes that are applied depending on the way disclosure is made. Usually it's 5 working days. The key to look out for is you're looking for the days 5, 7, and 9, because there are different types of disclosure. And there's different ways that you can provide the disclosure. And depending on how the disclosure is given is how long that cancellation period lasts for. So have a look for that, because again, if the lender fails to make that disclosure, then disclosure has not been made. There's also variation disclosure under sections 22 and 23 if we step away from initial disclosure. That's all the stuff that lenders have to disclose if the contract's changed. So you can think about it as change disclosure, but if you look at it in the Act, you need to be looking for variation disclosure. Variation disclosure can sometimes appear complicated, and lenders can be caught out. I know a lot of lenders are quite nervous about variation disclosure, so I'm happy to say that I'll spend a good 5 or so minutes today just talking about this particular topic so you know what to look out for. The third of the 4 core topics of disclosure is continuing disclosure under Section 18. That's the disclosure that your borrower generally gets every 6 months of the loan. And finally, there's request disclosure, which I'm sure a lot of you are familiar with. That's the right under Section 24 to provide to the borrower or you as their advocate copies of any of the core documents. And some of you may be aware of the time frame for providing that, but if not, then the lender must provide what you've requested within 15 working days from the date of your request, if what you've requested is one of the things that your borrower or yourself are entitled to under Section 24. So those are the 4 core types of disclosure. And I'm going to now focus on the new things that are coming. As most of you will know, those changes were meant to come in on 1 October this year. However, with COVID-19 and its impact on the recent alert levels, and the fact that everybody you hear from today is working from home, Cabinet decided to extend that date by 2 months to 1 December. So for everything I talked to you about today and everything Lizanne mentions later on, lenders have an additional 2 months to get their houses in order. A couple of weeks ago, I did talk about new disclosure obligations coming in, and I'm going to be answering lots of questions. So I think it's time for Sonia to ask a question. And I'm going to actually ask you, what are the 3 types of new disclosure coming, Sonia?
So I do now absolutely know this one. So we've got 3. They are financial mentoring disclosure, dispute resolution service disclosure, and the disclosure before debt collection.
That's right. Well done. You know, it's been a few of these, so I'm glad that it's stuck home. And I hope that the lenders who all heard about this, it stuck home with them too. In addition to those 3 things, a couple of weeks ago, I also covered 2 other areas. That was regulations have now come in clarifying what absolutely needs to be disclosed when the contract's changed or varied. And then some new rules about extra disclosure if lenders are advertising in another language, which I'm sure a lot of you will be excited to hear about. I really appreciated the amount of great questions that were asked about disclosure after I spoke a couple of weeks ago. I had said in the earlier that it's not the most exciting topic, but there are a lot of little rabbit holes you can go into with disclosure, and I'm glad some of you went down those. Most of the questions that were asked cover one of the 5 changes that I said I'll talk about. So I plan to go through each of those changes again, but with more detail following your questions and at the same time answering some of the questions directly that you've given. So the first thing we'll talk about is financial mentoring and dispute resolution service disclosure. We're going to talk about them together, even though they're separate obligations, because they're similar enough that we can talk about them at the same time. And they also both have the same consequence. If the lender fails to disclose the information, then it's an offence under the CCCFA and could lead to fines of up to $600,000. So it's quite a big tool we've got, and we'd absolutely want to know about it if a lender wasn't disclosing that information. So I think this is a good time for another question. Sonia?
That's great, Crystal. Thank you. Yes, we've got questions coming through on the chat, which is excellent. We'll make sure that we can try and get to as many of those as we can as we move through the session. I think I also wanted just to say that the session's going to be recorded and we'll send the links out afterwards. So yes, it's great. Take notes, but know that you can refer back to it. So Crystal, someone asked how the new disclosure obligations apply to current loans as at 1 December.
Yeah, that's a great question, and also one that the lenders asked, and I answered it for them because they do need to be aware of how the new obligations apply to current and new contracts. So for financial mentoring and dispute resolution service disclosure, again, they're separate obligations. The new obligations apply to new contracts from 1 December, as well as existing contracts, which are live as at 1 December. So from 1 December, new and old doesn't matter, provided the contract is live. This disclosure must be provided if the conditions are met. So what does it mean? Well, for financial mentoring disclosure, which I'm sure all your ears are ringing, well, from 1 December, if the borrower defaults, makes a formal hardship application, and or the lender declines a high cost loan application, then the lender must disclose information about the availability of financial mentoring services and where to find them. Now, the law now provides clarity around when lenders have to provide that financial mentoring disclosure if they're sending a payment reminder. The regulations provide that from 1 December, information about financial mentoring services must be disclosed to the borrower when lenders send payment reminders where the payment is overdue for more than 10 working days. So if they provide that information for a debt that's owing and a payment hasn't been met and it's not quite 10 working days yet, they're absolutely able to do that. I mean, they probably should, and I think the Responsible Lending Code talks about that, but it is an absolute finite, no negotiation obligation. If that payment is overdue for more than 10 working days, the information must be provided. When we ran this session for lenders, they asked us a few questions about what actually needs to be disclosed for financial mentoring disclosure. So we'll definitely look at that. Here's what we said to lenders. Penny's going to chuck a slide on for us. So, I've summarized for you on the slide what lenders must disclose come 1 December. Again, copies of these slides and this presentation will be made available to you at the end of the seminar. So please don't feel you need to copy anything down. So this information comes from Regulation 5A. It currently provides that lenders have to disclose a statement about the availability of free and confidential advice from an independent service. And I'll cover soon why we underlined independent service. I'm sure you'll all have a laugh. Lenders have to disclose the name and contact details of a building financial capability service funded by MSD that provides such a service. Now, why have I underlined independent service? I've underlined independent service because we had a question about whether a lender who works with their borrower to create a budget plan from the borrower's income and expenses could be considered a step. under the financial mentoring disclosure? So if you're laughing, don't laugh, it was a real question. The answer is obviously no. Lenders who want to work with their borrowers to help with their budgeting are absolutely free to do so, but this does not detract from the lender's obligation to provide information about free and independent mentoring services. So you'll be pleased to know that they'll still hear about you guys, even if the lender's trying to help them. And I should note here that the statement that must be provided is a statement about the availability of the services. It's not a requirement for the lender to actually provide the services or take any further steps, for example, connecting you with a borrower. And finally, I also just want to note, in case you saw it before, the earlier version of this regulation said that details had to be given about money talks. That's now been removed. Instead, it's the name and contact details of a local to the borrower building financial capability service funded by MSD that must be disclosed, including the contact details for that service. So Penny's going to pop a link to the amended regulation in the chat function, but if you were looking for wording around money talks, that's now been removed. Don't expect that when you see this disclosure that you need to find money talks, that's gone.
So, Crystal, this is probably a good place for another question. We had someone ask, this was a lender's question, about this new disclosure requirement that I think the people who are watching now, our consumer advisory audience, might be interested in. So a New Zealand-wide trading lender asked what service it should disclose for financial mentoring disclosure, as its borrowers were scattered all over New Zealand.
I think this was probably asked by a lender who thought they could just send out template disclosure, and that's not the case. So the first point I would make in answering this question is that the financial mentoring disclosure is tailored to a borrower's particular circumstances, and it's tailored to a borrower in particular. Template disclosure won't cut it. It's triggered by something that the particular borrower has done or has applied for. And so the lender should therefore be pointing that particular borrower to a financial capability service that's in the local area to the borrower. As we know, MSD's website has information on how to find local services, and we gave that information to lenders in the similar deep dive we did on this topic. The second point I'd add is if the lender is unable to provide information about a locally based service to the borrower, for example, the borrower is in an area where there's nothing nearby, the lender may be able to disclose the availability of a nationally based service instead. So for example, here, the lender could maybe disclose information about FinCap, because FinCap is the national entity for the building financial capability sector and is funded by MSD. So if you see a reference to FinCap, that's probably because a locally based service wasn't available, but maybe have a check about that, because that could be an area where the lenders failed to comply with that obligation.
Hey, so Crystal, one financial mentor's asked a question. They say, what's the best way for me to find out if lenders are disclosing the right information about financial mentoring services?
Yeah, it's a good question, because we'd also like to know whether lenders are disclosing the right information. As mentioned earlier, this new obligation applies to both existing and new loans. So because the disclosure obligation is triggered by default, a hardship application or the denial of a high cost loan application, it may be worth noting, say around mid-December, after a bit of time has passed after 1 December, to start asking your clients if they're new and coming in, whether they've received any information about financial mentoring services when these things have occurred. Especially if you're noticing defaults in the statements after 1 December, because that's when it kicks in. If your client says that they didn't or they can't remember, it might be worth noting this to the lender about it the next time you speak to them. You could also ask for a copy of the disclosure that they were meant to have given and how it was made. And if they haven't provided it or they didn't have the right information, then definitely please let us know. It's a new obligation and we really want to be making sure that lenders are meeting it. So you could just send us a heads up at notify@comcom.govt.nz, which Penny will pop into the chat function. And don't forget to tell us the name of the lender. I did see a live question come in and I actually can't help myself. One of the questions was, what happens if there are 6 financial mentoring services in the local area to the borrower? Well, the answer is the lender will just have the right to choose. And if they've got to say a familiarity with one of them, they'll probably pick that one. But the law doesn't require the lender to choose any one in particular. It's really just going to be their personal preference of a choice. Sorry, I couldn't help myself.
Thanks, Crystal. I saw that one go through too.
Yeah.
And there's been some other questions come through, but I know we're getting to that material later. So
yes.
we will try and cover off as much as we can.
Yeah.
Now we're going to turn to the dispute resolution service disclosure.
Yes, we will. So again, this one's from 1 December. So from that date, if the borrower makes a hardship application, complains about enforcement action, or makes any other complaint covered by the regulations, then the lender must disclose information about their dispute resolution scheme. Now, makes any other complaint covered by the regulations, that one's pretty broad. The Act, well, actually it's a regulation, it says that other types of complaints are basically any expressions of dissatisfaction where the borrower expects a response or a resolution, and it's something that relates to the actual lending service. So they can't complain about the colour of a dress, but they can absolutely complain about something in the loan. Anything like that, then this disclosure must be given if the borrower makes that complaint. We again were asked by the lenders what must actually be disclosed for dispute resolution service disclosure. So I've put that on the slide again. Again, this is Regulation 5A. This is the one that's been changed around. So I think this is a really good space to come find it on our slides, a summary of what needs to be given. Firstly, it's the name of the lender's dispute resolution scheme and that scheme's contact details. It's not any scheme, it has to actually be the lender's scheme because we don't want lenders sending borrowers to a dispute resolution scheme that won't help them. They also have to disclose a statement that the borrower has access to the service, that the service is free, and that the service may help to investigate or resolve the borrower's complaint.
And so, Crystal, the question we had before with the New Zealand-wide lending lender, where they said, you know, what dispute resolution service should it disclose for its borrowers? Again, because they were scattered all over New Zealand. You're thinking about that location and the services or the dispute resolution schemes that need to be offered to the borrower. How does it work for for national providers?
Yeah, well, I think the lender was a little bit on the wrong track. He went down a rabbit hole that I'm not sure where he got there, because it's not asking lenders to disclose any dispute resolution scheme. It's the lender's dispute resolution scheme that has to be disclosed. And the key here is the lender should already be a member of a scheme, so it shouldn't be hard to find out that information. And it's that scheme that must be disclosed, regardless of the location of the borrower or the service or the lender. I did see a question that said, does the complaint have to be in writing? The answer is no. Any mention of dissatisfaction, whether it be orally or in writing, would be absolutely fine. And if that's made, then this disclosure must be provided. But again, it's normally going to be provided once the lender's considered the complaint already. So what I would expect to see and what you should expect to see is when your client has made a complaint and the lender addresses it, in that correspondence where they're either accepting or rejecting the complaint, it's at that point that you would expect to see the information about the dispute resolution scheme.
That's fantastic, Crystal. Thank you. Now, so we've talked a lot about financial mentoring and dispute resolution service disclosure. Do you think now we should move on to disclosure before debt collection?
Yeah, I think that's be great. So this one, just like the other two areas of disclosure, applies equally to existing and new contracts from 1 December. So from 1 December, expect to start seeing these, which is great. You don't need to worry about when the contract was entered into, it covers them all. For this one, failure to disclose is an infringement offence and the lender could be fined up to $30,000. This disclosure must be provided before any debt collection steps start. And I had mentioned last time there are some exceptions to this, for example, when the goods are at risk.
And Crystal, I know we had lots of questions about this with regards to what is debt collection. Do you want to talk a little bit about the definition of debt collection?
Yeah, again, it's a legal definition, but in essence, it's anything to collect debt. So the Act defines it as an act to recover or an attempt to recover any money that's owing by a debtor under a credit contract as a result of the debtor's breach of the contract. So there does need to be a breach first. And debt collector similarly means a creditor or any other person engaging in debt collection in respect of the contract. So debt collector will cover agents who are acting for the lender.
That's great to get that clarity. So if I've got this right, if the debt goes to the internal collections department of a lender, then this disclosure will need to be made.
Yes, absolutely. So this disclosure applies to the lender and any agents of the lender who are collecting the debt on behalf of the lender. Yeah. Well, so let's look at what actually needs to be disclosed before debt collection starts. Again, on the slide, I've summarized for you what must be disclosed come 1 December. This time it's covered by Regulation 23. Hasn't had as many changes as Regulation 5A, so it's a little bit easier to follow. So firstly, again, it's the debt collector who has to provide this disclosure. That may be the lender when they're collecting the debt themselves, or a third party who's doing it on behalf of the lender. Regulation 23 currently provides that the debt collector must disclose information that will help the borrower identify the contract, so identify the loan. This includes the lender's name, the date of the contract, the type of the loan, even the purpose of the loan. It's things that will help the borrower identify the loan. Now, I'm sure that you're probably thinking, why didn't the law just require them to provide a copy of the loan? Not entirely sure, but of course you always have a right to go and ask for a copy under Section 24 of the Act. So we've told lenders for this step they don't have to provide a copy of the credit contract, but it'd probably be helpful if they did, so they should definitely consider it. But again, if your client gets this debt collection disclosure and it's not included, don't worry about it. They don't have to include it. You can ask for a copy later. So lenders must also disclose a statement about the debt. So there are specific requirements about what must be in that statement. They're a little bit complicated, but it'll be things like how much is currently owing, what was owing at the date of the last statement, etc. And then the lender must also disclose information about the debt collector if the debt's been sent to a third party for collection. This includes the full name and contact details of the debt collector and information about where the borrower can go to complain, including details for the lender's dispute resolution scheme and even information about us, the Commerce Commission. A statement about the borrower's right to apply for unforeseen hardship must also be disclosed, together with information on how to make that application. And finally, the lender must disclose a statement to the effect that if a person has concerns about their finances, then they can get free and confidential advice from an independent service. This must be disclosed together with the name and contact details of that service, and it must be one funded by the MSD. So that's similar to the financial mentoring disclosure. There are even requirements for disclosure before debt collection for where lenders put information within the document. So it's very prescribed. It needs to be in a prominent position, and the regulations do describe that in detail. I think after you've seen a few, you'll start to identify when one doesn't look quite right. And that'll be a good way for you to go and pick up Regulation 23 and see if they're disclosing it in the right way. As I said, all that information must be prescribed before the debt collection starts. It must be disclosed again if a new person becomes a debt collector after the debt collection has already started. In that case, it must be provided within 10 working days of the new debt collector starting. So depending on how many debt collectors are involved, it may mean the borrower receives multiple debt collection disclosure statements, depending on how many debt collectors the lender's using. But I think that's okay, because each time the borrower will be receiving up-to-date information about their debt and who to contact if they have any issues. I should just quickly say here that, of course, if a lender's using multiple debt collectors and you start going, what the heck's going on here? That might actually be a responsible lending issue as well, because I'm not sure a responsible lender would have multiple debt collectors that's raising alarm bells with you. But yes, each time there's a new debt collector, expect to see that disclosure. And if you don't, ask questions.
That's fantastic, Crystal. Thank you.
So I recall a lender asked a question around this. Can you remember what it was?
Yeah, absolutely. And it's a question I think that will be quite relevant to our consumer advisors. But I've just noticed there's quite a few new people that have joined since we started. So I thought I'd remind people that we are recording this session, that it'll be available to you later, and that there are detailed handouts on our website which go over all of the 5 areas that are changing, including the ones we're discussing today, disclosure and advertising. And we are answering questions. Both Crystal's doing it live, which is very clever of her, as well as at the end. So if you've got questions, put them in the chat. Now, so we had a question which is asked, if a new debt collector starts after debt collection commences, they've got 10 working days to disclose the debt collection information in Regulation 23. The question that we had is, since they've only just become the debt collector, they won't have the last disclosures statement. Can they simply populate one? How does it work?
Yeah, I'm glad the lender asked this one, because again, the lender went down a really strange rabbit hole. The disclosure statement that would be relevant here is the Act's Section 19 continuing disclosure statement. That's the one that the lender most recently sent. So the new debt collector is not going to have a last disclosure statement of themselves. They'll need to ask the lender for their most recent Section 19 continuing disclosure statement, and then populate all the information on the statement about the debt. So yeah, I'm glad they asked that one, because I'm quite worried about what they would have provided. I've talked now about the 3 new types of disclosure coming in: financial mentoring disclosure, dispute resolution service disclosure, and disclosure before debt collection. Now I'm going to talk to you about the wonderful variation disclosure. That's all the things that needs to be disclosed when the contract is changed. And again, the change can be a change that lenders imposed if they're able to do under the contract, or a change that the borrower and lender have agreed, for example, a hardship variation. So the variations you're going to be most familiar with is when the lenders agreed to change something with your borrower. It can be under the statutory hardship application, or just an agreement anyway, because now you're on board and you're trying to make things easier for your client. Also, things like credit limit top-ups, those could be agreed between the borrower and the lender, and those will be covered by variation disclosure. We've recently amended our disclosure guidance for lenders again to provide even more clarity around what they have to disclose when there's been a variation, because as I mentioned earlier, lenders are very nervous around this area. If you want to know the details about all those variation requirements, then I recommend you grab yourself a copy from our website if you don't already have one. Look in particular at Section E of the guidelines, which covers variation disclosure, and Penny will right now pop a link to those in the chat box. Might be good for you when you see variation disclosure coming in to go and look at Section E and compare what we say lenders have to provide against what lenders have actually provided. Before we get to the questions that were asked around the subject, let's just go through quickly what's required for the 2 types of variation. This table is a quick guide to variation disclosure, which I know the lenders really appreciated. Looking first at agreed variations on the left-hand side, lenders' obligations are currently set out in Section 22. Timing-wise, agreed variation disclosure is usually provided and must be provided before the change takes effect. For high-cost consumer credit contracts, agreed variation disclosure must always be provided before the change takes effect, so keep an eye out for that one. Turning to the crux of variation disclosure and what must lenders actually disclose when the loan is varied, Section 22, subsection 1 of the Act provides that for an agreed variation, full particulars of the change must be disclosed, together with any other information prescribed by the regulations.
That's great. And I'll just let people know the slides will be available after the session, so you can have hard copies of those, or have copies of those emailed to you.
Yeah.
And it's also good to note, Crystal, that we had really good attendance at our lenders seminars, and a high degree of engagement of lenders wanting to understand the legislation and the changes so that they could be more compliant.
Yeah. And especially on variation disclosure, because variation disclosure, like initial disclosure, are the only two disclosures that are covered by section 99(1)(a), which is that section that says if you haven't provided proper disclosure, you can't collect your interest and fees. Now, I'd mentioned that full particulars of the change must be disclosed. And the reason I did this is because it's not defined in the Act. So the Commission's view, and we've communicated this to lender, is that full particulars of the change requires lenders to disclose what's been changed, together with any relevant information from the list in Schedule 1 about that particular change, and the effect of that agreed change on any of the remaining key information in Schedule 1. Now, from 1 December, lenders will also need to comply with Regulation 4F when there's an agreed variation. Regulation 4F provides that in addition to the full particulars of the change, lenders must also disclose additional prescribed information, that's particular information set out in Regulation 4F, if the change affects one of 5 things. They are the credit limit, the annual interest rate, the total interest charges, the payments required, and credit and fees and charges if the loan is a high-cost consumer credit contract. I know we had a lot of questions around this area because, again, lenders are concerned about it. So let's go through those now. Sonia, can you ask me the first one?
Yeah, we had a really interesting one. The question goes, do lenders have to provide variation disclosure if the changes occurred due to statutory hardship request or temporary change in contract terms to assist the borrower? And I think this is an important question for financial mentors, because they're often making these types of requests to lenders.
Yeah, and I'm happy to say that this question was asked by one of you, but a lender asked a very similar question. So we've given this exact same answer to them. And yes, lenders will need to provide variation disclosure in both of those circumstances, even with temporary changes. But with temporary changes, the disclosure may be able to be provided after the change takes effect, depending on what was changed. The lender must meet certain requirements, but it's important for you to know that the lender must make those disclosures to your client, even if the change was only to lower the payment amount and extend the term. Again, in that case, it might be that the disclosure could be provided after the change takes effect, but the point is disclosure still needs to be provided.
Thanks, Crystal. Hey, so there's another one that I think could be relevant here, and it says, if a short-term payment plan is arranged, which will revert to the original payment amount after a period, will the lender still need to provide variation disclosure?
Yeah, absolutely. It's an agreed change. Obviously, the disclosure would only cover the period that the change was in place for, but I would also expect to see that the disclosure said, this is what you've agreed for this period, and this is what happens when the period ends.
So we've had another couple more come through on this subject. So I think there's a few people who are wondering about this. Can the variation disclosure be a document, or can it be an email confirmation to the client or the client's representative, or a phone call even?
Well, that's a good question. And I also saw one live in the chat box pop up about asking whether it can be orally. So I'll cover both of those. So there are no specific forms or formats that lenders must use to provide variation disclosure in order to comply with the disclosure requirements. There is one that it has to be in writing. So disclosure of the phone will not count. Disclosure in person will not count. It must be in writing. That's in section 32. So yes, the disclosure can be emailed if the borrower and the guarantor, if applicable, they've agreed to receive disclosure in that manner. And you can usually find in the original loan agreement a clause saying that the borrower will agree that they receive disclosure by email. And that's actually probably better, because when borrowers, sometimes they move a lot, if they've said, look, we want disclosure by email in the contract, or you as their representative have said, we want disclosure by email, then you can make sure that that disclosure is always getting to your client regardless of where they're living. And I should say here as well that disclosure can be provided to you as the borrower's representative if you have the client's instructions for that and you've told the lender about those instructions. But given it's probably going to be emailed, I think a responsible lender should probably copy in your client. But again, if they only sent it to you, but you gave that instruction to do so, that would probably be fine.
That's great, Crystal. Thank you.
No worries. Well, before I move to unilateral variation disclosure, I just wanted to look at the Commission's suggestion for how to provide agreed variation disclosure. We showed this to lenders at our seminar and they really liked it. We thought you'd be interested in it too. This is what you might see for variation disclosure. It's an example that we've put in our revised disclosure guidelines, and it's just one way we recommend that lenders look at disclosing their agreed changes. This way we feel shows the borrower the full effect of the change. You will see on the left-hand side, there's information on what the borrower is currently paying, and then on the right-hand side, what the borrower has requested will change and the knock-on effects of that change. Now, there's no requirement to disclose it in this way. This is not a variation disclosure Bible that all lenders will comply with. It's just a recommendation from us because we feel it's a good way to show the borrowers the change together with the effect of the change. So some of the smaller lenders who are dealing with 1 or 2 variations a day, they could look at something like this because inputting the information will be very borrower specific and a bit easier. Whereas a bank, for example, who goes and changes, say, a floating rate and has to send thousands of disclosures, probably wouldn't have the time to do this. So I'm just making it very clear this is not a requirement for lenders to disclose it in this way, but we thought that some of those smaller third-tier lenders who have real customer focus would probably benefit from seeing it this way and looking at doing it themselves. And we did have some really good feedback from lenders that they liked it. We did have one question about the table from a lender who asked what current meant on the left-hand side. So in this example, current is what the borrower is right now paying. The borrower could have agreed $100 initially, but what they're right now paying is $200. So yeah, that's what current means, what's currently in place. If we just go back to the quick guide to variation disclosure table, then we can look at unilateral variations as well. So that's where the lender imposes a change without the borrower's agreement. Those obligations are set out in section 23. Penny, if you just want to move to the next slide, be great, thank you. So timing wise, unilateral variation disclosure is usually provided within 5 working days of the change taking effect, or with the next continuing disclosure statement, depending on what's been varied. You'll normally see variation disclosure when a bank has changed the floating interest rate, for example. And back to the crux of what must actually be disclosed. Well, again, these full particulars of the change come in, but we now have a regulation that is from 1 December, lenders will need to comply with regulation 4G, which provides that if a contract is a high cost consumer credit contract, lenders must include specific information. So a statement about the rate of charge that cannot exceed 0.8% per day. It's called the rate of charge here, not just interest rate, because again, the rate of charge involves both interest and fees. Were there any questions for us about unilateral disclosure, Sonia?
Yeah, we had someone ask if, and this was a lender asked this question, if they would need to provide unilateral disclosure for changes to a floating rate.
Yeah, so this one, it's quite controversial for the banks because when banks change a floating rate, to date, they've not always provided individual disclosure. We have told the banks, and we're in discussion with the banks about this, so if it changes, we will absolutely let you know. But we've been in discussions with the banks because we say that, yes, the floating rate changes need to be disclosed because they have knock-on effects. So again, it's about our expectation that the change is disclosed together with the effect of the change. So if a floating rate is changed, they must disclose that. And the effect of the change will be, say, for example, an amendment to the payment amount or how long it will now take for the borrower to pay it off. So those are all changes, effects of the changes, and we feel and are of the view that that must be disclosed. It's a little bit of a working thing at the moment with the banks, but that is our view at the moment, and if it changes we will definitely let you know. And for now, some of you with mortgages might want to keep that in mind. Before we close off variation disclosure, the question that remains is whether the new regulations apply to all contracts from 1 December being new and current, and the answer is yes, they do.
Yep, they apply to new and existing contracts
That's
from
right.
1 December. Great. Hey, so we've got one last question about variation disclosure, and it's from a mentor. A mentor asked, will it be a requirement for lenders to notify mentors directly when changing loan terms for a client? They say sometimes they insist on dealing with the client even when there's a privacy waiver in place and when the client wants the mentor to represent them. And, you know, I think the point they make is that their clients sometimes don't check their emails about loan changes that might have been agreed with the lender. Can you tell us a bit about that?
I think this question is one that Lisanne would say is a bit out of the box. It's a bit out of the box when it comes to what the law requires lenders to disclose to borrowers about their loans, but I'll give it a go. This is more in the realm of the responsible lending provisions and the responsible lending code. So the code has some guidance about lenders needing to work with borrowers' representatives. In the code, there's a section called Working with Borrowers' Representatives, and one of the points in there might help. It says, where a borrower or guarantor has requested that the lender work directly with their representative, a lender should do so in good faith. This includes working constructively and collaboratively with the representative. So whilst the code is guidance and the law does not expressly require this of the lenders, then compliance with the code, though, is deemed to be compliance with the law. So what does that all mean? Well, it means that the lender is required to provide the borrower with variation disclosure. But where you have advised the lender that you are instructed by the borrower and the borrower has instructed the lender to provide you with copies of the disclosure, then if the lender still wishes to send the disclosure to the borrower directly, that's okay. But a responsible lender should also be sending you a copy. And you can feel free to quote me on that when you next talk to a lender about it. So we've talked about all the wonderful things about the new types of disclosure coming in and variation disclosure. This last type of disclosure I'm going to talk to you about is what must be provided to borrowers if the lenders advertise in another language. This one's the odd man out because it isn't technically disclosure as we know it. Disclosure that we've been talking about is very prescribed information. It must be disclosed at certain points during the contract, and there are real consequences if lenders get it wrong. This new requirement is found under the amended section 9C, so in the responsible lending part. The requirement is if lenders advertise in a language different from the one used in the loan agreement and the advert is less than 6 months old, then the lender may need to take reasonable steps to offer information about the loan agreement in the advert language. There are 3 things I just mentioned in that sentence that are able to be interpreted by different lenders differently. They were that they might need to provide the information, reasonable steps to provide that information, and information about the loan agreement. So expect to see disclosure about this in different ways from different lenders. But at the end of the day, the key here is that enough information must be provided in the advertised language to ensure that the borrower can reach an informed decision. So like I said, what lenders disclose is at their discretion as it's not prescribed. Obviously, if they wish to translate all of their documents into the advertised language, then that might be an option. But we really caution lenders on this because they would need to make sure that their translations are accurate. If any translation provided to your borrower makes a different impression or is even different to the loan document, then the version which is most favorable to your borrower is the one that will apply. And I made this very clear to them, so they needed to be very careful about providing translated copies of documents if they didn't match the original loan term. I've told them here that the key is going to be quality over quantity and ensuring that what is provided is both helpful for the decision making and accurate.
That's fantastic. Hey, so I just wanted to acknowledge that we're almost coming up to time, but we've got lots more questions to get through. So Crystal and Penny and I are really, really happy to keep going, and we're going to keep going. And we just want to acknowledge that if you have to go to another meeting, that's totally fine. We will be recording the session, but we'll just keep going, Crystal, I think, because there's some
Might need
really
to speak a bit faster.
there's some really good questions coming through.
Yeah.
Hey, so it's really interesting to hear about that, you know, especially the quality over quantity thing, and that accuracy. That's absolutely critical. And I understand that the revised responsible lending code also recommends that where the lenders suspect the borrower doesn't have a good understanding of the language that the loan documents are in, that they must have processes in place to pick that up. And then they actually have to go one step further and offer them that information about their agreement in the same language that they've been advertising in.
Yeah, absolutely. And again, because that's in the code, it's not compulsory, but we would absolutely look at responsible lenders who were missing opportunities to do this and possibly ask them questions why they weren't. I should also note here that this obligation I've been talking about to provide information about the agreement in the advertised language applies equally to guarantors. So if you're working with a guarantor who saw an advert in another language, they should have been provided information about the guarantee in the advertised language. Now for this one, failure to meet the obligation could lead to a pecuniary penalty of up to $600,000. So it's important that lenders have processes in place to pick this up, and we've definitely talked to them about it. Again, this one applies equally to new and current advertising as at 1 December. Now, because of the 6-month provision, what that means is if lenders have advertised or will advertise after 1 June this year, so think about current advertising, in a language that's different to the language in their loan document, then they may need to offer information about their loan agreement in the advertised language. So we have mentioned to lenders to have a think about what language they're advertising in right now, because come 1 December, this obligation could apply to them. If lenders advertise in a language different from the loan agreement language within a 6-month period, they must provide some information in the advert language if they think the information will help the borrower understand the agreement. So there are a few ifs in there, but definitely keep alive to the obligation, because if you think that it would have helped your borrower, a lender probably should have thought of that as well. One of the questions we had from a lender at the seminar was how the Commission would assess compliance in different languages. If the Commission was investigating this obligation, then we would obtain translations of all of the documents and then compare them against the loan document. Again, if the translated document did not match the loan document, then the term more favourable to the borrower is the one that would apply. Bless me.
Bless you.
So were there any other questions about this advertising one, Sonia?
Yeah, and it was really interesting. We got some really good responses about that, it being more favourable to the borrower. That was really, really clear to people. Yeah, so one lender asked, if I create a checkbox on the application form to ask whether English is a second language and it's ticked, do they then need to provide further information to the customer in their preferred language? You know, or I guess they were wondering, is it okay to check with them whether they're okay to converse, and can they read the contract, you know, in English?
I thought this was a really good question from the lenders. It shows that they are trying. They don't just want to treat their borrowers as a robot. You ticked a box and so now I can only talk to you in a particular language. So we told them that as responsible lenders, then they should be engaging with their borrowers to understand their English ability if they confirm English is their second language, because not all English second language speakers are equal. And it's okay for lenders to check with the borrower if they're okay to continue in English. But if they're not, or there's some red flags raised for the lender, then the lender should have processes in place to engage with the borrower in another language. Or, this might be a bit controversial to a lender, if it's not possible to engage with the borrower in the language that the borrower can understand, then the lender will need to consider how they can even assist the borrower if the lender is unable to converse with them in a language that they understand. And I'd also add that if lenders discover that their borrower or the guarantor, because here again it applies equally, if they discover that they don't have a good understanding of English, then they are also likely to be a vulnerable borrower or guarantor as defined in the Responsible Lending Code. So if the Responsible Lending Code is met in terms of they're vulnerable, then the recommendation there is that additional measures are taken for lenders to ensure that the agreement will meet their requirements and objectives, and that the borrower and or guarantor actually understand the contract. Additional measures will be needed.
That's great. Hey, Crystal, there's a really complicated question here from a mentor that I think would be good to ask. So they said, you talked about lenders being responsible for providing information in a language that the client understands. What about levels of cognition, about people's abilities? Is the lender also responsible to determine if a borrower is, able to understand the terms? And then what would that look like?
It's a bit of a tricky area, a bit of a rabbit hole. So thank you to the person who asked that question. It is actually great to be able to assist here, so I appreciate it. The Responsible Lending Code provides guidance on this particular point. In Chapter 14, which deals with oppression, there's guidance for lenders on how they can comply with their obligations and their responsibilities to make sure that their borrowers and guarantors aren't induced to enter into the agreement by oppressive means. At point 14.2, I believe it is, in particular, it provides that lenders should require lending staff and any agents who interact with borrowers and guarantors to consider whether there are any other matters which may lead them to reasonably believe that the borrower or guarantor may not be able to protect their own interests. So that would include, for example, mental condition, but also age, their physical abilities, what their home life looks like and things like that. If they suspect that might be the case, and again, reasonable lenders should be picking up on this, even if there's no clear red flags. It's about what they can tell from sitting with a borrower that is reasonably observable. Then the code guides us to say that the lender should take particular care when dealing with those individuals, especially when they're unable to protect their own interests, to avoid the possibility that the lender inadvertently enters into an unconscionable agreement. So what could a lender do? Well, it could include recommending that the borrower and guarantor get independent legal advice or other specialist advice, maybe asking the borrower's representative who's come along with them, like their family member, maybe to step out of the room so they could discuss some of the terms and things like that. It will be borrower specific, but there are most definitely obligations for the lenders to have a look into this when their spidey senses are alerted.
Crystal, I just want to acknowledge that we're now going to run over time, but that if you do have to go, that we're recording it, and so you can maybe mark, a point in time and pick up the latter part of the session in the recording. Hey, so Crystal, we've got one more question about providing information in other languages that I think could be really useful to discuss. And it says, if a mentor has a client who received information in their language, and this was all they brought to their budgeting session, can the mentor ask the lender for the contract in English if they don't understand the client's language?
Oh, absolutely. In fact, I'd say do it off the bat every time. It's a right you have acting on behalf of the borrower to request that type of disclosure. That's under the request section of 24 of the Act that I've talked about. And I say go for it, and it should probably be something you look at every time, because when you compare the two versions, that's when you can possibly pick up a term that's more favorable to your borrower. So a little hint there. Remember, though, that the additional language disclosure is only required when the advertising language differs from the language that the contract's in, and the lender considers it will help with the understanding. There should always be a contract, a base contract. Doesn't actually have to be in English, but there does always have to be a contract, a base contract. So it's a good idea to have your client tell you what they understand about the contract from having key information in their own language disclosed with them, and then you can test their understanding about what's in the base contract.
That's a really nice kind of segue, I think, Crystal, into the changes about advertising. So we didn't get too many questions about other advertising changes from our community audience at the seminar, but we did receive a couple of interesting questions from lenders that I think our community advisors audience will be interested to hear about. And I see that we've got a question coming through, and Penny's responded that there is a survey at the end. So if you have to go and you've got a question that you want asked, you can still get that to us. When you click out of the Zoom link, you'll be asked to go to a survey. And if you click continue, you can enter your question in there. We'll do our best to answer those and get them out to everyone. So when we're thinking about the new questions about advertising that we've got coming up, do you want to do a bit of a recap for us on the new rules for advertising?
Yeah, so these are different to the disclosure when someone's advertised in another language. This is actually more stuff coming in. So from 1 December 2021, lenders will need to comply with new advertising standards. They're set out in the CCCFA amendment regulations, and after 1 December, they'll be integrated into the current regulations. And that's probably a good point. I've mentioned Regulation 5A, Regulation 23, how they're all changing. From 1 December, you'll only need to go to one place, the CCCF regulations. So these new ones around advertising, lenders have to comply with as part of their obligation as responsible lenders. The standards set out certain things that lenders must do when advertising, and now certain things they absolutely can't do. They include things like if an advertisement for a loan states a payment amount, it must also state the total payments that will be payable. And remember, mobile traders are now caught, so mobile traders have to do it again. Or the annual interest rates that would apply under the loan also need to be disclosed. If the advertisement includes an interest rate, it must state the annual interest rate or range of rates if there's many, whether fees also apply. It has to state mandatory credit fees, whether annual interest rate is fixed for the term or part of the term. It has to say that in the advert, or not fixed at all. It all must be disclosed in the advert. If lenders advertise a loan as interest-free, the advertisement must clearly state, including the details of any mandatory credit fees, and it can't be just in tiny writing, but we'll get to that. All of those things must be stated in plain language in a clear, concise, and intelligible manner, which is wording from the Act. And regulations now prohibit certain advertising practices, which I'm sure a lot of you will be happy to hear about. Lenders must not advertise that they won't inquire into or take account of the borrower's circumstances. So I'm going to list some things that I'm sure you've heard of that they're not allowed to say anymore. They can't say no credit checks, guaranteed acceptance, bankrupt okay, or bad credit history okay. They can't say it anymore. If you see it, let us know at notify@comcom.govt.nz. If lenders mention the speed of approval in the advertisements, then they must also contain a prominent statement that it's subject to responsible lending inquiries and checks. So you know those approval in 60 minutes or payment in 10 minutes, that must come with the statement that the lender has to check responsible lending things first. Lenders who breach these obligations, which again are coming in under the responsible lending obligations, can be ordered to pay penalties of up to $600,000 for companies or $200,000 for individuals, plus there's statutory damages, which due to recent amendments of the Act is equal to the cost of borrowing, which are credits and fees.
That's great, Crystal. Thanks for that recap. Hey, I can see a question in the chat, and we had another question come up before about what needs to be included in a radio ad, or on television with a small font. If the radio ad or the television ad or social media ad only advertises who the lender is and how to get in touch, rather than advertising the interest rates, etc. What do the regulations require then?
Well, there's two parts of that. So the first one from the live Q&A right now is on a television ad, what about when the font is so tiny you can't read it? The answer to that is that advert will not meet the advertising standards, because the information that must be disclosed in the advert must be prominent, it must be clearly legible, you must be able to read it. Something that pops up and then, oh, it's gone, that won't count. Something you can't read, that won't count either. So that would be a breach of the new rules. Now, in terms of a certain lender you might have heard called MOOLA, who advertises via sponsoring competitions on radio, but they're not actually advertising a specific loan. I think that's the second part to this question. Now, for that, the regulations generally require lenders to provide additional information when advertising certain aspects about loans, not when just advertising themselves. So, for example, where the radio ad simply says, contact Crystal for finance for great loans, that's fine. There's nothing triggering in there about a particular loan that I'm offering, which means that the regulations step in. However, if the ad said, contact Crystal for finance for great loans, only 15% interest per annum, then there's got some triggered information there because I'm offering some terms, I'm offering the interest rate, and the ad must then also state whether fees apply, including any mandatory credit fees, whether the annual interest rate is fixed for the term, etc., etc. That's triggered. I should note, however, that if Crystal for Finance was a high-cost lender, then the regulations still require the warning I spoke about before, as that's applicable to every high-cost advertisement. So if MOOLA advertise that they're even in existence, because they're a high-cost short-term lender, they have to disclose some additional information.
Thanks, Crystal. Hey, so there's a question come through about websites being subject to this advertising standard. And I know we've had other questions come through both in the survey after the last session and in the chat about advertising and the new information when it's on small spaces like Facebook ads or Google ads. What's the Commission's guidance to lenders about that?
Well, the Responsible Lending Code gives some help in answering this question. It states that where the regulations require an advertisement must state particular information, that information must be in the advert itself. Lenders should not rely on providing the required information on a separate website that borrowers have to click to in order to get it. So lenders will need to think about these issues when choosing how they advertise. If the advertising space is small, then any required additional information can't be in microscopic font. So it's that example on the TV I mentioned, applies equally to a tiny Google advert. It has to be easy to read. We should expect some changes in the way lenders are advertising come 1 December. And if we don't, let us know, notify at comcom.govt.nz. Again, there are special regulations for high cost lenders, so those charging over 50% per annum. Every advertisement, whether it be for a specific loan or just for the lender, must include a prominent warning about the types of loans and whether they're suitable for long-term or regular borrowing.
That's fantastic. Thank you. Hey, now, so if anyone has any further questions about either disclosure or advertising, you can click the link at the end of the session, which will take you to a survey, and you can give us those questions there if we haven't covered it off now. But as many of you know, we have produced a new resource called Red Flags. And now I'd like to invite Lizanne Gibbs. She's our Senior Advisor for Credit Engagement in the community. And she's going to talk through how to kind of look for those red flags and how to use that resource that we've created. And Lizanne, I know we'll talk about this at the end as well, but if anyone doesn't have a copy, an electronic copy of Red Flags, they can email us at credit.advocacy@comcom.govt.nz. And they can also email us if they'd like a hard copy, a beautiful hard copy of it for their desk. So Lizanne and Crystal, I'll leave you two to discuss red flags.
Thank you.
Great, thank you, Sonia. Well, these are the things to keep an eye out for when you are seeing clients and working with lenders. Crystal, for our first one, what should an advisor do when their client doesn't recall receiving disclosure documents or disclosure about certain things like the information pertaining to a disabling device if one was installed in the car?
Yeah, these red flags are our baby, aren't they, Lizanne? We worked on them together for many, many days, so I hope you're all enjoying them. So for this question, first of all, it's important to know that disclosure can be provided in a series of documents, and if the contract provides for it, can be made electronically. So don't expect to see everything in one place and in hard copy. The best place to get all of the disclosure documents is from the lender. Again, it's that section 24, you can request them at any time. You can also ask the lender when you're requesting that information when and how they made their initial disclosure to your client. It may have been sent by email. And when you're talking to them about that, you could also ask how they assisted your client to understand it. And we would hope that responsible lenders are very open about this kind of information and how they disclose it to your borrower.
Well, while we're on that subject, sometimes financial mentors tell me they see contracts that haven't been signed. What is the status of a contract that hasn't been signed by their client?
Mm-hmm. My dad asked me this one all the time. They didn't sign the contract, so he doesn't have to comply. Well, legally, contracts don't have to be signed. You know, you can have contracts verbally. Lasagna and I right now could agree to, you know, buy your car, but there just has to be an agreement or understanding that the borrower wants to take the loan on the terms provided, and this is usually evidenced by the borrower receiving and using the funds. So short tip is, don't see a signature, don't worry, there still needs to be an agreement. Mentally though, your client must have wanted to enter into the contract and then received the money and used it.
Thank you, Crystal. What about new disclosure requirements for financial mentoring services? What if by June next year, budget services have not noticed an increase in referrals? Could that mean that lenders are not making the proper disclosures about financial mentoring services?
Well, no increase in referrals could be for a myriad of reasons, so it'd be difficult to connect it with the possible failure of lenders not making the correct disclosure. When we mentioned earlier about this, we said it would be a good idea to ask clients whether they are receiving information about financial mentoring services. So if you've applied for a statutory hardship application on your client's behalf, you should make a note to ask them about whether they received any information about mentoring services before they got to the point that they needed to make this application. It may seem strange because a mentor is making their hardship application, but it's the law, it should be part of the lender's processes, and the client should be receiving that disclosure regardless. So you should also keep in mind that the lender only has to provide the information and contact details. They don't have to do anything further. So that could be a reason why the numbers aren't going up for referrals, because borrowers are still not choosing to take that step. It is up to the borrower if they wish to contact the service and receive the help. They also might provide information about a different MSD funded service when the lender's providing that information, because it might be the one that's local to the borrower. So be aware that that might happen as well, especially if you're already working with a borrower. You might see that in the financial mentoring disclosure, they've referenced another financial mentoring service. That might be because that one's relevant to as local to the borrower and not because they don't like you. So please, if you see that, that is probably the reason.
Thank you. Here's another one. A mentor might be working with a client whose debt went to debt collection, and the client said that the debt collector only presented them with the total amount owing, and the client cannot think which loan that might be for. What should an advisor do?
Well, I think the first thing is to remember that this new disclosure requirement applies to all debts that have gone for collection after 1 December. That applies even if the contract was entered into before that date. If the debt was for a power bill or rent, then note that the debt collector wouldn't have to provide any of the new required information because those aren't consumer credit contracts. However, if the debt was for a consumer credit contract, then the lender would have to provide certain information, and that should have been done before the debt collection process started. If your client can't remember what the debt is about, if they provide the name of the debt collector, then you could find out whether it's for a consumer credit contract or not directly from the debt collector. You can ask the debt collector for a copy of the required debt collection disclosure and also the name of the lender that they're collecting for. If they don't provide it, you can complain to the lender about it. Failure to disclose this information can result in fines for the lender, so you might want to remind them about that.
Thanks, that's a good one to keep in mind. Thanks. We've got a couple of red flags around the new advertising rules. What should an advisor do if they notice a flyer that advertises a weekly price, but does not show the full price payable, but the small print provides a way to calculate it?
Well, remember that with ads advertising a weekly price payable, so often mobile traders, the full price should be shown in a prominent manner if known at the time. So in this case, if you notice the small print provides a way to calculate it, but the reader has to do some math or some complicated algebra, then this would suggest that the full price could have been known at the time that the lender made the advertisement and therefore should have been disclosed in a prominent way. So what can you do about it? Well, you could let the lender know. That would bring it to their attention, and you could also send us a brief note about it at notify@comcom.govt.nz. It would be really good for us to know how you spotted it and whether you brought it to the lender's attention. Next time, if they haven't made the necessary changes, they could end up facing a fine, and we definitely want to look into it. If your client bought something based on the weekly price, but perhaps would not have known or would not have entered into the contract for that product if they knew how much it would cost in total, you could definitely make a complaint to the lender, and all complaints should be taken seriously.
Thanks. One last one. What should an advisor do if their client took out a loan because the advertising suggested a speedy approval, no questions would be asked, and or their circumstances would not be considered? And this is after the 1st of December.
Yeah, well, if you remember from earlier, they can't do that anymore. So what I would do is I'd ask your client about their loan application experience, including when and where they saw the ad. So was it online, was it text, radio, etc.? As I've mentioned earlier, advertisements can't represent that the lender will not fully look into the borrower's circumstances, or that the loan has been approved already if affordability and suitability assessments have not been completed. So find out from your client whether questions were in fact asked. If no questions were asked, that's a huge red flag, especially for potential responsible lending and the failure to comply with the new advertisement obligations. We definitely want to know about it as well, so definitely let us know.
Great. Thanks, Crystal. That's all for the red flags. I'll now pass you over to Sonia.
Thanks.
Thanks, Lizanne. And thanks, Crystal, for your expertise and your time and your energy. We're really, really grateful. And it's been a pleasure once again to hear you talk about these very interesting and important subjects. We're really grateful for the time.
They are interesting. Thank you.
Yeah, that's great. Okay, and so, and of course, you know, to everyone watching, thank you so much. We really, really appreciate all of your time. So just like last time, we're going to run a survey, and Crystal, you'll be able to receive those questions as they come in, and we'll work out a way to answer them and get that information out to you. So at the end of this session, when you close the window, you'll be redirected to an anonymous survey. You can pop any questions here and also let us know what you thought of the seminar. It helps us to improve. So Crystal, is there anything else you'd like to add before we close?
I think I've probably done enough talking, so I'll leave it at that.
That's fantastic. Thanks once again. So if you have any questions or you'd like any information about this session or any of the other sessions, you can email us at credit.advocacy@comcom.govt.nz. We have 2 more sessions today, responsible lending and also the dispute resolution schemes. And then there's 1 more session on Thursday. And if you'd like any details about that or any of the other sessions, you can email us, we'll let you know. So kia ora koutou for your great listening skills. I'll close as we started with karakia. Unuhia, unuhia, unuhia ki te uru tapanui. Kia wātia, kia mama te nāko. Te tiana te wairua e te ara tangata. Koe rā e rongo, whakaere ake ke runga. Kia tina, tina huie, tae kie. Haere rā.